We got a lot of folks for Anat today. Anat's going to talk to us today about unicorns. You all have her CV. I'm not going to recite it all, but look at it. We're very pleased that you're able to join us today, and you'll be getting emails to me about forms and all that kind of stuff. But I don't want to take up any more of our time. So I'm going to turn over here.
Perfect.
So,
Thank you. Thank you so much. Well, thank you so much. Honestly, it's a huge honor to be here with you today. I wanted to present my paper. It's called Unicorn Stock Options, Golden Goose or Trojan Horse. And you're probably wondering, what are these unicorns? I was wondering the same thing myself. So unicorns are private companies. They're startups. They're valued at over $1 billion. And what's happening is they're really rare because in the past, venture capital-backed startups would do an IPO very quickly, within 4 years. And now they're staying private for longer than 11 years. Now let me walk you through how I even started this project. So before I came to NYU, I'm at NYU now, I was teaching at Dickinson, and I was obsessed with the decline IPOs in the US market. And I'm a huge Matt Levine fan. He's a Bloomberg columnist. He writes about corporate law and finance. And I get this email from Matt Levine that says, people are worried about unicorns. I was thinking, okay, what are these unicorns? Well, of course, I Google it up, and I see we have this new type of firm. Again, it's the startup that's staying private longer. And I took that email, and I sent it to one of my former students who is still working at Goldman Sachs, and I told him, are you concerned about these firms? What's going on? He said, yes, we actually are. And he sent me a paper by Gornal and Strambulaev that says that the valuations of these unicorns should really be slashed in half. So they are concerned about the valuation of these firms that are private. And I started thinking and doing more research about these firms, and what I found was, when I used to practice law, I would write a lot of stock option agreements for startups. And I knew that when you are a company, a startup company, and you give options to employees, after 10 years, those options expire. So what's happening now is these companies are staying private for longer than 11 years. After 10 years, the options are about to expire. So what I found was that there are legal barriers to private ordering. What does it mean? There's two things. There's securities laws and tax laws that prevent these firms from efficiently contracting with their labor force. And let me explain. Let me give you two examples. With regards to the tax laws, let's take Uber as an example. Uber is a very famous unicorn. Depending who you ask, today it's valued at about $80 billion. The venture capitalists that want to take it public say it's valued $120 billion. If you looked at the tender offer they had with SoftBank last year, it was valued at about $50 billion. When it was founded in 2009, it was probably worth pennies. So let's say you're an employee that was hired in 2009, and you were lucky. Why? Because now you're a millionaire, a billionaire, a figure if you got options from Uber. 2019, next year, what's going to happen is those options are going to expire, and you will have to make a decision. Are you going to exercise your options, or you're going to forfeit them? Now, if you exercise the options, so one of the questions I get at that, what's the problem? They're millionaires. Why should we worry about these people that are going to exercise their options? Well, if you exercise, then you have to pay a very large tax bill. Why? Because in 2009, it was probably worth pennies. Now it's worth, depending on you ask, about $80 billion. You're going to have to pay a lot of money immediately. Now what happens if Uber doesn't do an IPO? So one of the ways that you would be able to pay for your options, especially if the company is publicly traded, you can sell them on an exchange. When the company is private, like Uber, yes, now we have secondary markets, but unfortunately, most of these companies don't really allow their employees to sell their stock on secondary markets. Why is that? Now we're moving through the securities regime. If you are a company that will allow people to sell your stock, then people will have to provide material information about the company, okay? Most of these companies are private. Because of different safe harbors under the securities laws, they don't have to file what we call a registration statement with the SEC. So they don't have to disclose their material information. They don't have to get audited. They don't have to tell you exactly how much they're really valued. So if they allow people, Uber has over 10,000 employees. If they're going to allow 10,000 people to sell in secondary market, how can they control what kind of information those people are going to provide on the secondary markets? Because what's going to happen is that if the employees are going to provide material information with the company, then not only will the employees be able to be, if there are lawsuits, people will go after the employees, they'll also go after the company. So in most of those agreements, they now also put provision that you cannot sell, you cannot transfer that stock in the company if you decide to exercise. So what's happening is you're actually locked in. You're locked into a private company. Why is that a problem? Let me give you another case with litigation that was recently a Delaware court, a company called Goods Technology. So Goods was a unicorn. The company was so valued by its employees that the employees not only exercised their options, they also went to secondary markets and they bought additional stock in the secondary markets. But what happened? Goods, again, was a private company. It had some financial difficulties. And then it was sold to BlackBerry for half of its valuation. So in these companies, you have different types of equity owners. You have preferred stock, you have common stock. Usually employees are common stockholders. So what happened was the preferred stock would have what we call preference in liquidation and others, and they were basically bought out by BlackBerry, and the employees got nothing. So not only did they put took on loans, maybe put a mortgage on their house to be able to pay for all that stock, they ended up with nothing. And that's why the interesting part was it wasn't just the employees who brought the lawsuit. Delaware. Now we have new players in this market, mutual funds and sovereign wealth funds. The people who actually aggregated the lawsuit and brought the lawsuit were the mutual fund holders. So what mutual funds are now doing, they're coming in at later stages in these companies, and they're buying blocks of stock. They buy preferred, they buy common. What they realized is they got some return on their preferred. They didn't get anything on the common. So the mutual funds actually brought the lawsuit to Delaware. They aggregated the employees as well. And this is part, and let me move to the securities laws quickly. Let me give you another example. There's a company that's called Facebook. So before 2012, Facebook had to do an IPO. Why? As I said, these companies are private, they're safe harbors. One of the safe harbors before the Jobs Act in 2012 was if you reach a certain number of employees, at the time, before 2012, it was 500. If you reach over 500, then you have to file a registration statement with the SEC. Facebook realized, well, if we have to file a registration statement, if we have to provide material information about the company, we might as well do an IPO, because our competitors are going to know everything that we're doing. So there was a lot of lobbying, and interest group pressed Congress. One of them was the National Venture Capital Association. The other was a very well-known unicorn, Palantir Technologies, that gets a lot of funding from the U.S. government. And they were able to change the current laws. And under the new act, the threshold of employees was extended to 2,000. What's happening today, and that's actually the topic of my next paper, I'm writing a follow-on on this paper, is that there's a lot of pressure again on Congress. Who is it this time? Now we have additional powerful interest groups. As I told you, a lot of mutual funds have recently joined, and BlackRock and others want to allow non-accredited investors invest in private equity firms. Why? Why do they want to do this? Because there's a lot of money to be had. If people are going to invest into these companies that are private, then, and we're going to change the rules and we're going to allow non-accredited investors invest in private equity firms, there's a lot of money and interest and others, and who's going to do the monitoring? So another thing that I'm documenting in my paper is that a lot of the VCs are actually exiting. Mutual funds are buying their stake, and who's monitoring what's happening in terms of corporate governance into these firms? That's why we have so many scandals in these firms. Because mutual funds, when they come in, they co-invest with private equity firms, and their incentive structures are very, very different. So if a venture capitalist, for example, would insist on something like stock options. Why? Because stock options are a signaling tool to investors. If you know that an employee is willing to take equity ownership in the firm, they believe in the firm, right? It's a signal that the firm's doing well. If employees don't want to take an equity in the firm, to you as an investor, you're like, okay, what's going on? What's going on with these firms? The employees don't want to take an equity. So there's really two structural issues here. One, with regards to earlier hires, and two, with regards to later hires. And let me explain. There's a lot of empirical research that actually Jay Ritter from the University of Florida was able to collect on the fact that, as I said, these companies, instead of doing an IPO or trade sale after 4 years, they're staying private longer, for 11 years. So in the past, after 4 years, those early employees, they're the ones who are contributing to the capital in these firms, because we're talking about human capital. The capital of these firms is intangible. These are tech startups usually. So they would leave the firm and they would compete. They would start their own firms. What's happening today, because of all the money that they would have to leave on the table, they don't want to leave that money on the table. They're staying private longer than 11 years, and they don't compete. And what's happening with the later hires, they figure this out. Why? Because of artificial intelligence websites like Payday and others, and Google, that reports on employees in these companies who are complaining about their equity. So people are saying, okay, why would I join Uber and then not get anything? In the past, you would join a startup because you have an upside. You get equity, and you're going to become a millionaire one day. If you know you're joining a unicorn and you don't know if it's going to be sold, you don't know if you're going to get anything at the end, after a year and a half, these employees are leaving. So we really have this pervasive situation where the people that you want to leave in terms of innovation economy, you want to have knowledge spillover, they're staying. And the people that you want to be trained, they're leaving very early. And that's why I am proposing two things, two reforms. One, I think there needs to be a comprehensive reform to the tax laws and securities laws. And let me explain why. Recently, there has been two pushes for legislation that have failed. One, there's the new Tax Cuts and Jobs Act. That what it did, it gives an extension to Section 83 under the tax code. What it does, it gives people 5 years to defer their taxes. So if you work for one of these unicorns and you can have 5 years to defer your tax liability. But if you talk to practitioners, most likely many of these firms are not going to be able to use that legislation because of the way the act is designed. It's designed to give broad-based compensation, and you can't have any liquidity events. And again, as I said, these employees are stuck. What they want is they don't just want to defer their taxes, they want to have a liquidity event. So what the tax code basically does is it says if you're going to give the employees a deferral, they won't be able to liquidate. They can sell, the company cannot do any buybacks. So it gives relief on the one hand and then put other constraints on the other. The second thing is, when we do any sort of reform, we also have to take the securities laws into account. Now, Jay Clayton, who's the chair of the SEC, is saying that they want to continue and do more reform to the securities laws. And I say, okay, but you need to decide. On the one hand, you're saying, I'm concerned about the decline in IPOs. On the other hand, even before 2012, what you've been doing, you've been deregulating the securities laws. You've been allowing these companies to stay private longer and are making it very difficult for employees to liquidate. We have these secondary markets, but it's very hard for these companies to trade on them without having clear, definitions of what kind of material information they need to provide. So make it easier for them to decide, do you want to see more IPOs or do you want to see more private companies? And I personally believe that we should go back to having more IPO. I think all this deregulation, and especially letting non-accredited investors invest in these companies, is not a good idea. I think we need to have more material information. If nothing else, I would like to be able to do more research and gather more information on these companies. But seriously, we're talking about billions of dollars that are in the economy, and we don't really know. There's a lot of opaqueness. We don't know what's going on. So I think we need to know what's going on in these companies. In the past, we had certain thresholds that we believe that investors had a right to know what's going on in these companies. And I think that's what we should go back to.
Questions? Have any questions?
Talked a little bit about this morning. I really liked your paper, by the way.
Thank you.
The real concern here, the impediment to knowledge spillovers. We talk about how California doesn't recognize non-competes, and this is sort of a backdoor way to have a non-compete. And it seems like a good follow-on. I'd love to hear your thoughts on this. This is more of a long-term project, that the people who do the startups usually leave these other places. They cash out with a liquidity event, then they start their own company, they compete, and you have this wonderful cross-fertilization in California, a little bit different than Route 128. It seems to me that you're onto something here, how the innovation space, which I know you're also interested in, will take a hit long-term because these employees are now tethered to their employer with no way out. And what's going to happen 3, 4, 5, 10 years down the road? That seems to be an adequate impetus for California to also pressure Congress to sort of revisit the types of proposals and laws that you're thinking about.
Thank you so much, and definitely, and what's happening is, for example, in California, it's not easy for a company to do something like buybacks. So California has blue sky laws, and they have restrictions. Companies can only do 10% buybacks. So California also has an interest, I think, for these companies. It's a real concern to not be able to do this. That's why, at least in Stanford, at the Rock Center, they're very much against what's going on now at the SEC. So that's definitely a concern there.
What is the market failure here? These employees, are locked in for a longer time. They can always leave, and but then in the long run, I mean, of course, they become a victim of their own success because they can't leave because the industry was deregulated to allow these companies to remain private for longer. Everybody thought that they were going to win. It turns out that that's not what happens. Well, what happens is, won't the market itself find a new equilibrium in people that instead of joining new startups, they will go somewhere else. They will go back to finance, or they will go to medical school. And why should the law step in?
That's a great question. Actually, Marcel Kahn asked me that question. And that's why I said there are legal barriers to private ordering. What do I mean here? The market cannot fix what's going on. We have legal barriers that are going to prevent the companies from efficiently contracting with their employees. And there are 2 legal barriers. One is the tax laws, and the second is the securities laws. With regards to the tax laws, as I said, people want equity. That's why they work for startups. Okay, that's what they're used to. And there's all these new alternatives that companies are trying to offer them. According to the tax code, after 10 years, your options are going to expire. Okay, and then you don't get any of the tax benefit, and you have to exercise or forfeit. They are trying to give restricted stock units, but they are more expensive because the fair market value now of the companies, it's a unicorn, it's billions of dollars, much higher. So let's say if you would give, let's say, 1 apple that's a restricted stock units versus 10 bananas that are the options. People want the bananas. That's why they joined in. That's why they joined the startup. So buybacks are not going to be as efficient, as I said, because of securities laws. That's the other impediment. So you can't just buy them up. Bonuses, they're great, but if you want a bonus, you go work for Microsoft.
I understand, but these are problems for people who are in it.
Yeah.
All right? What I'm saying is, the companies that are benefiting from this system right now, this deference, right, 10-year period, won't they lose if they keep doing it? Because then they won't be able to attract the same talent. Because the talent, if the talent is worth, smart enough to be so valuable to the company, the talent should be also smart enough to also know that I'm locked in.
And
So
it-
the talent's gonna go somewhere else. Why is that a problem?
And the talent is smart enough. Not only is it smart enough, what these companies have done is now they raise the salaries. So if in the past you were able to offer them less compensation for with a higher equity, now they raise the salary, so it's a competitive salary. They up the equity, and the talent still doesn't want it because it's much more beneficial for talent to diversify your investment. Why? Let's say there's cliff vesting. So usually you get options for 4 years. After 1 year, there's the cliff. And so they just jump from one unicorn to another, and they diversify. They stay for a year, then they move to another company for another year, and if you're giving them, some companies are now doing 10 years on the company's paying it, of a deferral in paying. After you left the company, just to be able to compete, what it does is actually it creates a wealth transfer. Why would I stay and work for a company and give you the option to exercise up to 10 years after you left? Because I'm the one that's going to continue to make the company profitable. And then you're leaving, and I still have to work. So none of the solutions are really beneficial, and it's a new problem. Maybe they're trying to come up with, different ways, RSUs, bonuses, and other things. And they really have a choice to make. On the one hand, private placements are very attractive. Why? Because we have mutual funds. We're investing billions in them. And the founder, and I didn't mention this, the founders now have an incentive to stay private longer. Why? In the past, after the IPO, Mark Zuckerberg is, an exception. Most CEOs don't stay after the IPO. 90% of the cases, according to empirical evidence, the CEOs change, okay? Usually, you bring in somebody who can handle a public company, okay? The CEO took the company to the public markets, 90% of the cases in the CEO change. What's happening now is that the CEOs are able to liquidate. They sell their stake with other investors that are coming in. And the longer they stay, the longer they get to enjoy a very high salary, control this very private company that has all the benefits of a public company. You have thousands of employees, you're all over the world, and you have more money flowing into you, and you have this very, luxurious status of being a unicorn. So you have an incentive to continue to keep your company private. You're not subject to the oversight of the market. So analysts don't really know what's going on, in the company. So yes, they're losing their talent, and they'll have to come up with a way to fix it.
I have a bunch of comments. I'll get to you one way or the other at some point, but I just want to follow up on what Juscelino was asking. I mean, as I read it, and as I look at this landscape, right, equity and in particular stock options are a uniquely good way of compensating early employees in a risky startup in terms of aligning everyone's incentives and maximizing their payout while not having a lot of upfront expenditure. But they only really work if at the end of the day you're going to have a public market for the securities, and that's what I thought was fascinating about this project, is that it raised a bunch of larger questions about the role of public securities markets, right? That it's insufficient to think about them just in terms of this is a way of raising capital for companies. They might not really be all that crucial to raising capital for companies anymore with private markets out there. But nonetheless, they have a role in allowing for these efficient compensation schemes. They have, roles in liquidity, diversification, opportunity for small savers to invest in equity, and maybe most importantly, production of information by creation of market prices, which is allows for efficient allocation of capital across the market. So I think it's an interesting project that you could build on the fact that we need to take into consideration more than just the ability of companies to raise capital in designing the incentive structures for managers to either take their firms public or keep them private. There's a whole lot of public considerations that impact it. I also had a question on the market failure question. For me, the question I kept asking was, what are the obstacles to private order in here? Not necessarily in redesigning, how you're going to compensate the employees, but if it's making it hard for startups and unicorns to attract and retain human capital, the best employees. Couldn't the VCs or the other big investors, like the mutual funds, step in here and buy provide liquidity to the employees the same way they're doing to the founder, if that's a problem, and still avoid the having 2,000 investors and having to disclose? I mean, couldn't they put in these contracts that after year 3 the VC will let you exercise your options at whatever the latest price was?
Thank you. That's actually a great question. What's happening is that we're seeing some of the later rounds doing that. For example, the SoftBank tender offer. So what happened with SoftBank was, so SoftBank came in and they wanted to buy a share of Uber. And what they did was they allowed, but this was really something that was interesting, fascinated me. They put in restrictions. Employees that had 10,000 shares and were accredited were able to sell. So not to buy. Usually you need to be an accredited investor to buy. Why did they make it so they could sell? Because they wanted less employees to be able to do that, because there's a locking effect. So the companies on the one hand, yes, they want to provide liquidity. On the other hand, their most valuable talent, they're locking them in because none of those, are not enforceable in Silicon Valley.
Yeah, so I mean, ex post, right, they want to lock them in. Ex ante for a company trying to attract good employees now, they might want to offer them the prospect of the VC's going to buy them out in a couple of years.
And they only allow up to 10% of them to buy them out. So they still want them to have a stake in the company, and they just allow mini liquidation events. And the other thing is, for the company, it's more beneficial, what I call is private secondary market, because then you can also control the threshold of how many people hold equity in your company. So we're going to see actually more of that happening. But it's not going to solve the entire problem, because we have a lot of employees, and every time it's just a small, and it's usually very senior ones that are going to get that perk. It's not going to be across the border. It's not going to be to most of them. And with regards to mutual funds, the other problem is VCs are exiting these investments. They're making a lot of money. The mutual funds are coming in, and for example, Josh Lerner just had a really nice paper. He's from Harvard about mutual funds is investing as VCs in these companies. Are they really investing as VCs? Are they monitoring their investments? What are their incentive structures? How long are they investing for? They get very aggressive redemption rights, right, when they invest. So if we're going to look at something very different, they usually don't take any seats on the board. They ask for aggressive redemption rights. And VCs sometimes take aggressive redemption rights too, but they've never exercised those rights. What happens with the first mutual fund that decides to do that because their investors want their money back? Then that entire system is going to collapse, I think, because who's going to lend the company any more money once mutual funds are going to start exercising those rights? So it's really also a structural issue here, what's happening with all the money coming in. And then we also have sovereign wealth funds that now they have other incentives. They want to invest for the long run. They're very passive. They don't care. They just invest, at least from my discussions with private equity fund managers. They're investing them. They're going to continue doing that. Why? Because the returns are very high. And the other thing is their incentives, the mutual funds and sovereign wealth funds, the incentive is not to have an IPO because of the different restrictions. They don't want there to be an IPO. They want to be able to control the valuation of the firm. So again, it depends who's now controlling the board of directors. What's happening is they're letting founders have more control over the board, and that's why we see more scandals. So there's really a lot of issues.
So building on that last point that you just made, I'm curious about how the availability of these different sources of capital might influence the business models that we see these companies adopt, right? So if I think about VC investment and the set of incentives that creates for a company towards like really fast, aggressive growth, early exit opportunities, I mean, that might drive certain decisions and in certain ways kind of pathologies that we might be worried about in terms of, a race to build a really large user base, trying to deploy a product or a service at scale really quickly. And I think we've seen examples of how that's not necessarily a great thing from consumers' perspective sometimes. You kind of hinted at this. I wonder if strategically companies make different choices if the capital is coming from sources that don't encourage that kind of very quick, aggressive growth?
That's a great question. That's actually something that I'm trying to figure out. It's very hard for two reasons. One, to know who are the players and how much are they investing. As I said, Josh Lerner, what he did was really nice. He looked at all the certificates of incorporation of these companies, and then through that we can see who's starting to invest in them. But what I do know also from practitioners is that two things have changed. So in the traditional VC model, traditionally, VCs would control the board of directors. What does it mean? They would have oversight over the board. They would be able to guide the founders, okay? What's happening now, because of all these new players, the boards are now being controlled by the founders. So VCs are coming in at what we call founder-friendly rounds. They don't monitor as much. They want to exit, right? So they have 5 to 10 years to exit. So what they're looking for is who's going to come in, buy their share. They want to also push the valuation up and exit. So their incentives are very, very different than somebody that would want to take the company public. So you're looking at different things here.
Could you have a contracting solution for this? So, ex ante, you have this employee going into it with the possibility of stock options. And then you have the problem that after 10 years, they haven't gone public. And so the employee will have will forfeit it or will pay large taxes. So could you, and then you're worried about attracting talent. So could the employer then say, well, if this happens, if we're still in business after 10 years and we haven't gone public, we'll indemnify you or we'll I don't know, give you some other valuable right to compensate you because of this risk. You know, it's kind of a risk premium. Could they devise something like that?
That's actually a great question, and a lot of lawyers are making a lot of money now trying to figure out what to do with these companies because of two things. One, now we know that these companies are staying private longer, so we can take it into account. So what happened with the early employees, when they joined Uber, for example, in 2009, they didn't dream that Uber was going to become a unicorn. This whole unicorn thing, even the term, is as of 2012. So this entire phenomenon is, so let's say from now on, if I'm representing a company, can I put in provisions of, let's say, what you're offering is like some sort of liquidity and loans and things like that. The problem is, let's say I actually want to take the company public in the future, right? And I give loans or I buy back those, equity stakes from the employees, then how do I explain to my investors later on? I would have to clean all the balance sheets because I just give millions of dollars of loans to my employees. Mm-hmm. That's also going to be very problematic. Mm-hmm. So I wish there was like an easy solution to this, but it's hard also from that perspective that if you do, and at least they say they want Uber to go public, right? And they've already, by the way, they've been struggling with this in the past, I want to say even 4 years, because they knew 2009. And a lot of the pressure, by the way, on 2009 on Uber is because SoftBank bought a lot of that employee equity too. So they were already starting to give RSUs, which is restricted stock units, so the vesting is going to look very different. What you get is going to look different. The risk is going to be different. But you don't have as much of an upside with restricted stock units as you do with options. And again, when you join a tech company, one of the reasons you're willing to take the risk is because you want the high reward.
There's another aspect of your paper, and even its title, that intrigued me. I'm interested in some of the audits. And so the idea that this concept of unicorns came about in 2012, who coined the phrase? How did it catch on? Why are they calling them unicorns when there's now like 300 and they're decacorns in other companies, so they're not so rare anymore? How's the concept holding up?
Thank you. So actually Eileen Lee, she's a venture capitalist in 2012. She saw this company that are worth over $1 billion, they're startups, and she said, okay, this is rare, that's why they call them, they're almost mythical, because what I know from working with startups, and I've worked with startups both in Israel and in New York, I know that most startups, 90% actually fail, okay? And even the 10% that don't fail, they're having such a hard time raising money. So to have valuation of billions of dollars before you go public, you wouldn't see, VC-backed companies doing that. So, and I think we're gonna actually continue to see that China is the big player. So the US is currently leading, but China is definitely pushing towards that direction. I was in Toronto in the summer, and they had a conference on why they don't have unicorns. So they're concerned about the fact that they don't have unicorns. In Israel, another example, they have 2 unicorns now. And why? Because of the restrictions of having mutual funds invest in these companies. So what they're looking at is legislation, and they're debating, do we want to let these players invest in these companies or not? So that's something that and let's say we do, like they do here in the United States through the regulation. What about secondary markets? That's another issue, right? So we have secondary markets. Some people are saying, okay, they can be efficient if we have more companies trade on these markets. But that's problematic as well. There's problems with the secondary markets, because who's going to be trading on these secondary markets to begin with? Probably powerful actors like VCs and others. And the valuation is not clear. So one day you'll trade with Uber, valued at 70. Tomorrow you'll trade with Uber valued 50. So what are you getting as a consumer if you're going to turn to these secondary markets? So it's really an issue, I think, in terms of valuation. And again, depending on how you value these companies, there's also a debate on how we should value these companies. There are different methods of calculation too. So, yes.
You advocate for more IPOs. The Jobs Act, while it did for some companies with revenues up to $1 billion, and given certain shareholder makeup, could remain private longer than they might otherwise. The main focus of that part of the Jobs Act was on actually encouraging IPOs and creation of what became known as the IPO on-ramp, and a new classification of company within that less than $1 billion revenue company, of an emerging growth company, and providing easier ways for them to navigate the entire